The bankruptcy estate. So when you file a bankruptcy petition, you create a bankruptcy estate, and that's where all your assets go. And it includes these types of real property: what you owned at the time of filing, what you've acquired by inheritance or divorce within 180 days of filing a bankruptcy. So either 180 days prior to filing, 180 days while you're in the middle of bankruptcy, doesn't matter. That's going to get sucked up into the bankruptcy estate. What you hold as a tenants by entirety, husband and wife, joint tenants, or tenants in common. So you hold property with somebody else, whether it's your spouse, whether it's a friend, whether it's a cousin. You hold title where it's your name and their name in title to the property. That gets sucked up into the bankruptcy estate. It doesn't matter if, the wife, let's say it's a husband filing bankruptcy, wife doesn't have to join in on the bankruptcy, but her portion of that property is going to be put into bankruptcy estate. So that's one thing to think about. And that's one thing we look at too when we're talking, when we're reviewing a lot of the docket, who owns title? Because just because you're like, I own title with this person, they filed bankruptcy, why is my portion being brought into it? It's because it's a federal rule. All of your property, doesn't matter who you own it with, gets into the bankruptcy estate. There are some things that happen later, but in the beginning, all of this gets brought in. Your homestead property gets brought in. Any trusts, you can't avoid bankruptcy by putting property in trust. And then any property acquired during bankruptcy. So people buy properties during bankruptcy, that's going to be part of the bankruptcy estate. But there are schedules. So you file your petition, and then there are schedules. Schedule A is the real property. You're going to list all the real property that you own. And that has to be filed with the petition. Schedule C, this is the important one. This is the exempt property. This is where you're going to file your homestead property, because there's a big exemption when you're filing for bankruptcy for your homestead. Homestead in the state of Florida probably has the greatest protection out of any other state. There's constitutional laws. So when you talk about probate, whatever, basically the homestead property is untouchable. You have to file this exemption and claim it as an exemption with the petition. Then you have some other various schedules. You have the creditors holding secured priority, holding unsecured priority, holding unsecured non-priority, and it explains what each of those are. Usually judgment liens, mortgages, things like that. Credit card debt, all of this is going to have to be filled out just based on priority. So we file the petition, and like I said, the next step really is the meeting of the creditors, and that's where this is the only time the debtor typically goes to court, and they meet with the trustee and the creditors to discuss why they're filing bankruptcy, their current financial situation, all that stuff. Creditors typically don't, no one's from the credit cards company is going to go to the creditor meeting. So it's usually between the bankruptcy trustee and the debtor, but the bankruptcy trustee acts sort of on behalf of those secured or of those creditors. And then once that meeting's held, it's 30 days for objections for any creditor to come back and say, no, I don't think they need to go through bankruptcy. I think they need to pay me. That typically doesn't happen, especially in a Chapter 7. Chapter 11, possibly. Chapter 13, maybe as well, but Chapter 7, typically no. But what happens to real property in bankruptcy? So as soon as you file that bankruptcy petition, the automatic stay goes into effect. Nobody can touch anything because it's all part of the bankruptcy estate. So this is where we need to know what's going on. The property is vested in the owner. They file that bankruptcy petition. It immediately becomes part of the bankruptcy estate. Now there are things that can happen with. So here's your little graph. We're going to talk about each of these. The property, if it's exempted as homestead, or it's abandoned, or the plan is approved for Chapter 11 or 13, or the case is dismissed, the property is revested in the owner. So all that means is they get the property back outside of the bankruptcy estate, and they can do whatever they want with it. The other option is, if it's in the bankruptcy estate, then the property is sold by the bankruptcy trustee to someone else. So if one of these 4 criteria at the bottom isn't met, then the bankruptcy trustee has the right to sell the property. So once again, we're looking at on the title end, what's happened? Is there a homestead exemption? Was it abandoned? No. Then does the bankruptcy trustee have the right to sell it? So let's look at some of these. The homestead exemption, like I said, state of Florida, constitutional protection. One of the things with homestead exemptions is because Florida's rules were so protective of homestead, we had people moving into Florida filing bankruptcy to avoid having their $1 million houses as become an asset of the bankruptcy estate. In fact, our favorite O.J. Simpson actually did that. So after that, Florida courts are like, no, this is what's going to happen. We're going to have some rules and limitations on what the homestead exemption is. So it allows a primary residence of unlimited value, could be $30 million home, to be protected, or a $10,000 home, doesn't matter. It can be protected from creditors as long as the debtor has lived in Florida for at least 730 days before filing the bankruptcy petition. So essentially, they've had to have actually physically lived in Florida for 2 years prior to filing bankruptcy. If they haven't lived those prior 2 years, they're going to have to use the state law of the state they lived in is going to override whatever the Florida rule is, because technically you haven't lived in Florida for 2 years. Whatever state you lived in previously is those are the exemptions we have to use in those state rules we're going to have to follow for bankruptcy. Bankruptcy is a federal court, so they're going to, if the bankruptcy court's here in Florida, they're going to follow the Florida rules. If you are a Florida resident, if you're here in Florida and you lived in Georgia a year ago, they're going to follow the Georgia rules. It's a federal court, so they're not limited just like, oh, just because I'm in Florida, we follow Florida rules. It doesn't work that way. Federal court will pick and choose. But know that you have to have physically lived in the state of Florida for 2 years prior, 2 years prior to filing bankruptcy. Other issues for homestead: the property cannot be larger than a ½ acre in urban area or 160 acres elsewhere. And then before claiming the homestead exemption in Florida, you must have owned the property for at least 1,215 days before the bankruptcy filing. So you have a 2-year residency, and then you must have owned the property for almost 4 years prior, 3.5, whatever it is. If you can't meet the requirement, then you're limited by federal law, and the homestead exemption right now is capped at $160,375. So let's say you own a $350,000 home, but you're not meeting this homestead residency requirement, then all you can claim or avoid debtors touching is $160,375. I think that's you have to fill it out on the exemption schedule, so that Schedule C has to be listed on there. If it's not listed on there, it's not considered homestead property. The court's not going to be like, oh, is that homestead property? No, you have to fill out the proper petitions and schedules. It's really important. Just on a side note, you can file bankruptcy yourself. You can go through, there's Google it and you can find out how to file bankruptcy in Florida. But this is where it gets tricky. You leave off things, you leave off exemptions, you leave off certain things. It gets harder to redo those things later on. That's why I always recommend using a bankruptcy attorney, because they can guide you through, they can walk you through a lot of this stuff. And especially when you're trying to keep your homestead property from being included in the bankruptcy estate. So 30 days from the meeting of the creditors and there's no creditor objection, then the homestead property, it's exempt, we're good to go. That property revests in the owner, and owner can sell it, do whatever they want with it, because it's taken out of the bankruptcy estate if it's the homestead and it meets these criteria. If there is a creditor objection, then we need an order from the court telling us or denying the objection, and then we have to wait that 14 days for appeal for them to for the creditor to come back and say, no, I still object to it. So that's kind of the trick with it. If we've got 30 days from the meeting of creditors and the homestead exemption is approved and we're good to go, that property revests in the owner and they can sell it without the bankruptcy court being involved. So that's for our purposes on the title end and your end. Like, where are we? Have you had the meeting of the creditors? Obviously, as a realtor, you don't necessarily have to deep dive into it. We're going to do our docket search on the title end because we're insuring this. So we want to make sure all of these, like the T's are crossed, I's dotted on this. The second type property that can be revested back in the owner once it's gone through the bankruptcy estate is abandonment. And this is where the court determines that the property is burdensome, inconsequential, or it's likely underwater, and even if it was sold, unsecured creditors wouldn't get a thing. So, you know, we saw that a lot, especially during the foreclosure crisis when everybody's property values sank. You know, they're like, even if we sell it, this poor seller is going to have to pay, you know, is bringing in $30,000 to close or whatever. It's not worth it for us to sell it. There's nothing for the unsecured creditors to get. So they abandon the property. It's a court order of abandonment. Same thing. We have to wait to see if there's any, once we get that abandonment order, we still have to wait those 14 days to see if there's any objections from unsecured creditors or other creditors. And if there's not, we should be good to go. But abandonment's pretty easy. Court order gives it to us. We wait an additional 14 days. Sale in the bankruptcy estate. Where we're not exempted or abandoned, the trustee may sell after notice in a hearing. So this is where the bankruptcy trustee, it was our little side box on our graph, they're going to be able to sell the property, and they'll sell it as the bankruptcy trustee of the, you know, bankruptcy estate of whoever is the debtor. 21 days notice prior to sale to all interested parties. So they're going to have to send out notice to all the creditors saying we are selling this property. Objections have to be filed not less than 7 days prior to sale. And if there's no objections, we're going to get, the bankruptcy trustee can sell it without a court order. So once again, we're looking at the docket. Where are we? Has there been objections? If we've got nothing, we're good to go. There's no objections. There's no court order. Bankruptcy trustee can sell it without any issue. If there are objections, that's where we need a court order. So the order authorizing sale is entered. It's stayed for 14 days, which is that time for appeal. So anytime we get that court order, we wait 14 days. It applies to mortgaging property as well. So when we're talking about this bankruptcy and buy and sell, or selling property, sorry, this is what we're talking about just for sales. Mortgages are going to have to get approval a lot of times from the courts. If someone wants to refi or whatever, they have to be approved in a different process. I mean, it's the same process, but it's going to be a little different than the selling, because the property may be revested in them, in the debtor, but the bank may still be like, we don't want you to get any additional debt, so you're going to have to get approval for a mortgage. So then sale pursuant to a confirmed plan, this is for chapter 11 or 13. So this is another way the property gets revested back in the owner. So upon confirmation of the plan, it falls out of the bankruptcy estate and revests in debtor. The plan has to, or the sale has to be consistent with the approved plan. So this is where we get, you know, let's say the plan says you can sell the property for such and such amount, and you're selling it for a higher amount or a lower amount, and it doesn't meet the plan requirements. We're going to have to get a court order at that point. If it falls within the parameters of the plan, we're good to go. So these are all things that are listed out in the bankruptcy proceedings that we're looking at. So sale of jointly owned property, because like I said in the beginning, what's included in your bankruptcy estate? Property you own with other people. And the bankruptcy trustee can sell the debtors and co-owners' interests. They have every right to do that, because that property has now become part of the bankruptcy estate. Co-owners, spouses, joint tenants, tenants in common, however you're listed, doesn't matter. One of your co-tenant files a bankruptcy, that property is getting brought into it. The only thing is, the co-owner has the right of first refusal to the sale. So they can come in, they can, buy them outright, they can say the price is too low, too high, whatever. They're going to get right of first refusal. If the court overrules them, then they're going to sell the property. It is what it is.